Good afternoon, everyone who's just joining our webinar. We're gonna wait just a little bit more just to get more participants to join before we're gonna start. Let's say, shall we wait for another 1 or 2 minutes before we start? Kun Shanakan.
Yes, that's okay with me.
Okay, cool. Okay, shall we start now, Kun Shanakan?
Yes, okay.
Okay, so officially, good afternoon to everyone again, and thanks for joining our webinar. Young Professional one has been a while that we didn't see each other due to this COVID-19 situation. So thanks for joining us again. And may I just introduce myself? My name is Pinya Pasompong, or many of you know me as Amy. I'm the Chief Office Legal of Evermore Company Limited, and also the Director of the BCCT as well. And we have our guest speaker today, Kun Shanakan Bunyasit, or may I just call you Kun Kwang, right?
Yes, please. Just call me Kwang.
Okay, sure. So the Kun Kwang is a partner of Siam City Law Nishimura, and she's a lawyer of excellent academic standing who specializes in labor and employment law, corporate and commercial law, and commercial contracts. She's first obtained the LLB from Chulalongkorn University with the first class honors, and then proceeds to obtain an LLM or the master degree from the University College London with the merit. And she began her legal training with Wirawong CNP Limited. Kun Shanakan is also a qualified notarial services attorney. At present, she's a member of Thai Bar Association and Lawyers Council of Thailand, as well as associate members of Chartered Institute of Arbitrators. Moreover, she has been a guest speaker on Thai employment law and Thai personal data protection law in various domestic and international events, and a part-time lecturer for a few universities in Thailand. Kun Shanakan is also a regular contributor to a number of domestic and international law journals as well. So thank you again for joining us as our guest speakers. I know that today is a public holiday, and thank you so much for spending your time with us today. So
it's my pleasure.
Yeah.
Thank you.
So as many of you know, that our topic for discussion today is about the fundamental rights of the employees during this COVID-19 situation, which I believe some of you probably facing the problem regarding to the employment with the HR, I would say, or with the employers directly, which it leads to some uncertain idea whether you should or you shouldn't do. Should you accept whatever your employer asks because you don't want to get fired, or how you should react or reply with your employer when it comes into the, let's say, employment negotiation. So probably we're gonna move to the first question first. So I believe that like with this situation at this moment, I'm not sure how it works with your office at this moment. Kun Kwang, are you still working as a normal working hours or normal working life routine from Monday to Friday?
It would be difficult to say because for lawyers, it's already different from other career already. We already work flexible hours, but from our office, now our lawyers are working from home and we attend the office like on a necessary basis. So we attend office like once or twice, it depends. Some lawyers still go to court, yes.
I see, okay. But is it normal if the employee just come to ask you, due to this situation, I don't want you to come out from home, and we don't have that much of clients, so basically they're gonna ask the employees to, let's say, change the working schedule, maybe from 5 days, and then they reduce into 3 days instead, and also changing the working hours as well.
Yeah, that would depend. So long as they do not touch the employees' wages, so long as the employees' wages is not affected, then it is okay to do so. So So when we talk alone about like reducing working hours, that could be considered as more favorable to the employee if their wages is not affected. And when I'm talking about wages, it could be salary, or under Thai law, it could be other monetary payment, which the law might interpret it as wages as well. So if you reduce the employee's work, like for example, if the employees required to work 8 hours per day, and you would like them to work like 6 hours per day to reduce the working hours, then this is okay. Or if you would like to change, so long as you do not change their normal working day, such as they work like Monday to Friday, and you would like to make them work like Monday, Tuesday, and Friday, this is also okay. But you cannot change like from Friday to Sunday instead, because that considered as the change of the agreement relating to conditions of employment, which is not favorable.
So as an employee, we have the right to say no if the employer changed the working schedule unreasonable way, isn't it?
Yes, that's right.
Okay.
And so if also if the employee would like to reduce the if the employer would like to reduce the employee's working hours, and they also would like to reduce their wages proportionately to the reduced working hours, this is also considered as not favorable to the employee. So the employer cannot do so. They need the employee's consent first.
Right. But can we just say no to the employer in that case?
Actually, yes, because according to the law, for any employee who disagree with this change, the employer cannot impose that change to the employee. For example, if the employee's salary is, for example, 20,000, just say,
yep.
And the employer would like to reduce their working hours from 5 days per week to 3 days per week, and they would like to reduce their wages to 10,000 baht, for example. The employee can say if they would like to agree with this proposal or not. For employees who agree, then the employer can apply the new scheme. But for the employee who do not agree, the employer cannot just force them to. So for the employee who do not agree, they will still entitled to their 20,000 baht salary per month.
Right. So in the case that, let's say, if we agree because we know the situation, what's going on, and we think we can agree with them, should they do a bit more like, a proper written letter, like the details, how much they're gonna reduce, until when, and until when their salary gonna go back to normal or something? Should they get at least some writing through emails or the letter from the employer?
Yes, they should. And actually, when we talk about the employee's consent, I'm talking about express consent. So it should be in writing. So it would be like evidence for both parties. When I'm talking about like written consent, it could be in any form. So it means that the employer may like put an announcement that he or she would like to reduce the employee's salary by 10% everyone. And the employer may ask the employee to sign in one and the same document that they acknowledge and agree with that announcement. Or they could do like separate negotiation. They might enter into like one-on-one on that particular employees to do this consent letter. So it can be in a form.
Okay, just a little bit more on that. So based on your experience, do you think what should be let's say, the key point that the employer should mention in the consent letter, at least for us? If we receive it, we just want to make sure that it covers our right on that. Okay,
so if you are talking about reductions of wages, so it should specify like how should that amount will be reduced and for how long, because we know that this is the situation and it's going to be like temporary situation. It should have like some reservation that, okay, probably now the situation of employer is not good, but to protect the employees' right, and also to help the company to sustain this situation, it should be for corporation and it should be specified for a certain period of time.
Okay, that's good. It is always good to know when, you never know when that situation arrives and you receive the letter of the employer and you're just doubting, is it going to be the layoff letter or just reduce the salary?
Yes, that also like quite tricky point to consider actually, because when you agree for the reduction of wages, and some of you may already know that when it's come to the part of termination, and when we talk about severance pay, the law say it must be the last rate of the employee's wages that will be taken into consideration. So it means if you already agree to reduce your wages, this might affect the amount of severance pay, because the smaller amount of wages will be used as base for calculation.
That is quite tricky, isn't it? So this means, let's say if we receive the salary at 20,000 baht monthly and we gave the consent to the employer that, okay, you can reduce the salary down to 15,000 for 3 months. And on the last day of the third month, the employer comes to you and say like, I'm sorry, we can't go any further. We have to let you go. So it means that the base salary for the severance payment calculation will be 15,000.
Yes, that's right.
Okay, that's good to know. That's good to know. So just be careful, you all. make sure you read every single details in the letter first before you sign anything.
Yes.
Okay, right. So, what would happen? So now the employer has the right to, let's say, reduce the working hours or change the working days reasonably. Yes. And what if the employer decide that, I think we don't have any clients, so let's just cease the business at this moment, especially for the hospitality, I think, which is, I think the COVID-19 affect them a lot. So in that case, do they have the right to, just cease the business and don't pay any salary, or we still entitled to receive the salary on monthly basis?
Actually, this is a very complicated question, like situation, because we are talking about I'm sorry, I need to mention this section of law. Okay, we call it Section 75 of the Labor Protection Act. So many of you may already heard about this already. Why I have to say about this section, because this section will allow the employers to temporarily cease their business, and during that temporary suspension, they will pay the employer at least 75% of their wages. So it means the employee do not required to work, but they do not entitled to full salary, which is different from normal concept of employment. For normal concept of employment, the employer may assign or not assign any work to the employees, so long as they pay them in full. So this is different concept. But it's not in every situation that the employer can apply this section of law. So the employer has to be able to prove that there is like an important reason and it's not force majeure. This reason has affected the employee's business, and to the extent that the employee cannot operate it further. It's very important to know that this must not be the employer's own fault. For example, if this come from like the miscalculation or the plan did not go correctly, and they would like to use this situation where they would like to apply to use Section 75 under the LPA, this will not be allowed by the law. And when the employer would like to apply for this section, they will need to inform both the labor authority and also the employees at least 3 working days before the temporary closure of the business.
Right. So when we talk about the force majeure, do you have any definition based on the, let's say, the labor precedents or anything?
Actually, according to the previous precedents from the court, they apply the another law, which is our civil and commercial code. So it could be conclude that if the event is preventable, if person has taken appropriate care at the level that should have been expected from him or her or from other people in the same situation, and the reason still occur, this would be considered as force majeure under the law. So the difficulties would be if the COVID-19 situation should be considered as force majeure or not. And if it's considered as force majeure, what will happen? Because for Section 75 of the Labor Protection Act, it must not be a force majeure event. So if it's force majeure, the law does not say anything. So this is where we need some interpretation.
Yeah, how we define it, isn't it?
Yes, that's right. So in March, we got like an announcement from the Labor Authority. This is not a law, just a guideline, but it's the guidelines on how to interpret this temporary closure of the employer during COVID situation. So according to that announcement, if the employer's closure of business is resulted from the governor's order, if this is the case, the Labor Authority consider this as force majeure event, where it's not the fault of the employee, it's also not the fault of the employer. So if this is the case, the announcement said that the employer does not need to pay the employee at all. So this is under no work, no pay principle.
Ah, right, I see. Because I think this is a very important point, because many of us still understand that if the employer said that they're going to cease the business for a certain amount period of time, it means that no work, no pay, and we are not entitled to receive any salary on a monthly basis, which actually is not true.
No, but if it's for other reason, not because of the governor's order, if it's, for example, the employer's own discretion that, okay, we should close down the business for this moment as like measures to deal with the COVID-19 situation, not to spread it around or something like that, then the announcement said that the employer may consider to apply Section 75. So it means for other reasons besides the governor's order, if the employer applies Section 75, the employer is required to pay the employee at least 75% of their normal wages. But if they do not apply for Section 75, it means that the employees must entitle to their full wages.
I see. Okay. So I believe you probably have read the emergency decree announced by the government a month ago that, let's say, mainly in Bangkok or actually with other countries as well, that they announced that we should stay home and we have the curfew hours of that you're not allowed to go out from home after 10 p.m. So with this interpretation and in compliance between the law and the fact itself, do you think the employee could use this term of the curfew hour or emergency decree to say that, because the government announced it this way, so it's a bit more force majeure, that it's not my mistake, so no work, no pay for you for 3 months or something like that?
Actually, I don't think so. The regulations, the curfew regulations, is not against the law, and the same concept still apply, because it might affect, like for some employees who do the night shift or their normal working hours is like at night, but under the regulations they also have like exceptions for the employees who go out to work. If they have like normal shift or normal working time at that particular hours, then it's okay. So the employees cannot say that, okay, this is the case where I cannot leave my place, I cannot go to work or something like that.
Okay. So let's say in case that there's some company that is a mutual agreement between the employer and the employees that we're going to cease the business and we're not going to pay you because no work, no pay, and just to help each other between the inside the organization, let's say. So I'm just wondering that if there's some tricky employee that they come to negotiation with the employer and say that, during the cease of the business time, I got sick. So I got also the medical certificate issued by a proper hospital and signed by the doctor that I got sick, and I have to stay in the hospital for 5 days in a row. And during these 5 days, can I use it as a sick leave? So basically, during that 5 day, I still be able to claim for the salary for you to pay. Can it be that way?
I afraid I have to say no, because according to the labor authority interpretation and also the final court judgment as well, if the employee would like to exercise any leave, that means that the employee still work for the company. So if it's like during the suspension, during the closure of the business, the employee do not work for the company at that time, so they cannot use the right to take sick leave or any other leave as well.
Right, so it means if they stop the business and that's it. So you can't use the sick leave as an excuse to get the salary anyway.
No, but if the employer closure of the business is not from the governor's order that I already explained, the employer cannot just say that, okay, this is no work, no pay, and they do not pay to the employee at all. No, because this is not the case under the interpretation of Section 75 according to the Labor Authority announcement. So at least if the employer applying for Section 75, the employee will still be entitled to at least 75% of their normal wages.
Okay. And
but,
so, yeah.
Yeah, sorry. So, yeah, just going to further explain that if the employer closed their business, but they still can, they can still ask the employee to work for them, such as certain business, they can work from home.
Right.
Okay, this means the employees still work for the employer during that time, even though they do not come to the office or their workplace. And in this case, the employer cannot apply for Section 75 as well, because Section 75 means it's suspension of business, right? Temporary suspension of business. If the employee can still work for the employers, they cannot apply for Section 75. The employee will be entitled to wages in full.
Okay, and in that case, if let's say if the employee, some of them facing this illegal decision that the employee, let's say, comply with the organization and whatsoever, if they want to, let's say, complain, or if they want to report this illegal decision of the employer, what organization that they can approach, and if they're the expat and the foreigner, can they just contact the government authority in the sector that they can speak English, or what they should do in that case?
Actually, they can contact the Labor Protection and Welfare Office of where their workplace is located, because this depends. It's comparable to revenue office, so it depends on where the location of the workplace is, and they will have Labor Protection and Welfare Office that taking care of that particular location. So you can go and talk to them. You can verbally seek for their advice, and actually for this authority you can also file a claim to them as well.
But they also have the sector that the officer can speak English as well, right? Or they need to find.
They normally have, or if they do not have, you can ask your friends or someone to accompany you and be as an interpreter. This would be quite helpful, because for this labor authority, they have limited time for the labor authority has to figure out they will try to bring the employer, negotiate with the employer and the employee, trying to solve the problem. It's faster than the court.
Right. Okay.
Okay.
And yeah, okay. So guys, I also have one last question for you, Kun Kwang, but before we're gonna move to the last question, I just want to highlight again for those who are watching us through the live in Facebook. Basically, the next session of us will be Q&A. So we will not accept, or I won't be able to read your question through the Facebook comments. So please feel free to move from Facebook Live through the webinar. You will see the barcode to register, so it will be easy for you. If you have some questions, just drop us the question through the webinar in the next session. So yes, sorry, Kun Kwang, for the last question for me is that what if the business of the employer didn't go along well, and it comes into the conclusion that they need to shut down the company, and it turns out that the employer, they don't have enough money to pay us for the, let's say, all of those compensation and certain payment, how we should do?
Actually, the employees can still like sue the employer, because even though they come to that point of dissolution or liquidation, the entity still like exists for a further a while for all the liquidation process. So it means that their legal entity is still there. You can still sue them, and if you win the case, and if the employer owe you certain amount of money, and if they go bankrupt, you need to proceed along with the bankruptcy proceeding to get the payment. But for the employees, they will have like some preferential rights. So you will get certain amount paid before other creditors of the employer. And if I'm not remember wrong, I think about 100,000 baht for each employee would be under the preferential right that the employee could claim this amount from the employer.
So in that case, just curious, who gonna pay the lawyer fees for the employees?
Under the labor cases, we do not have the concept that the parties who win the case can ask the lawyer's fee from the other party, because of actually for the labor court, it's free. So you don't have to pay any fee for filing a claim. So the court and the law consider that if you file a claim with the labor court, it's all the expense of the lawyer shall be borne by that particular parties. So in that sense, the employees will have to be responsible for that lawyer's fee.
Right. And it brings you about the how long we talking about the time to go through like the all of these dispute? Probably
for the employment case alone, it's quite fast now. It's less than a year. It's less than a year. But we are talking about like, because we have like the appellate step, right? So this could be longer. It depends on if any disagreeing party has made the appeal against the cause of first instance judgment or not. So for the appeal, it could be few months, but less than a year as well. Now the step could now the proceeding is much faster than before.
Okay. Right. Okay. Thank you so much, Kapun Kwang. I think it's quite useful information for us to know what is right or wrong at this moment, because there's so many articles published about the employer's rights, employees' rights, and for us sometimes the details in each article is not really accurate, or it's kind of like it doesn't match if you're comparing between 2 or 3 articles. So it's very useful. Thank you so much, Kun Kwang. And for those who have the question, we're gonna open for the Q&A at this moment. So if you attend through the webinar, you can just type to ask the question, and I will try my best to read all of the question, and we'll let Kun Kwang reply you on this regard. Okay, I think we are open for the Q&A time now. Okay. we got the question that how can employees protect themselves if their employer is pressuring them to take a voluntary pay reduction? That's a good question.
So actually, it depends on what is your viewpoint, because at this time the employer, you have to differentiate between two types of employer. One, they really need cooperation in order to sustain the business, but one, this might be a first step for them to go further with termination with lower costs. Because if you already agree with the wages reduction, then that amount would be considered as your last rate of wages. So you have to consider about this, and you have to weigh the situation by yourself if this would be considered as like if you really trust your employer or not. If you do not agree, you can just say that, okay, you do not agree, you do not want to sign anything. Please don't sign anything if you do not agree to the reduction in wages, because once you sign it, it will be evidence against you that you already agree with the new rate of wages. According to the law, the employer cannot force you. If you do not sign, they have to comply with your decision. Nothing they can do. There might, in certain situations, the employer might try to terminate the employees, giving the reason that they're trying to reduce the overall cost, and some employees, they do not coordinate with these measures. But in that sense, you will be entitled to all the the termination payment under the law, and you may try with the additional damages for unfair dismissal as well.
Right, but let's say if the employer, they're really pressuring us, like put all of the pressure with the work and everything, and somehow forcing us to sign the letter, and you reach to the situation that you don't want to take this pressure anymore, so it's okay, you're gonna sign, or it's kind of like time is clocking and you have to sign as soon as possible. And are there any organization that you can report about this kind of, I would say, is this misconduct or some misconduct of the employer?
It's not kind of misconduct, because it would be hard to prove from this step, because the employer would say that they're just seeking for coordination to the employees who will coordinate with them. But if you feel that you do not want to reduce wages and the employers keep putting pressure on you, you may bring the matter to the Labor Protection and Welfare Office that I have already mentioned. Okay. They might come and try to mediate the situation, and it would be more into legal matter if you already say that you disagree with the reduction in your wages, but the employer impose the reduced rate of your salary without your consent. Then this is the matter that's against the law, and the labor authority will come in. You need to report to them.
Okay, thank you. And we move to the next question. Bruno asked about would you know when the Social Security Fund is supposed to be paid? I think in this case, presuming that might be during the cease of the business.
The Social Security Fund, it's very depending on the government authority, so I cannot confirm about the time. But to be entitled to that particular benefits, you still need to be like the relationship between the employer and the employee must still exist, and you have to pay certain contributions to the Social Security Office. I think
really limited time that, let's say, you have to contribute the money from your salary to Social Security, not less than 3 months or something like that, to be able to claim for the fund.
Yes, there are specified time. I have to check. I'm not quite sure about this, but once you qualify, and you must not receive any wages from the employees at the time that you would like to request to receive these benefits. So it means that if, for example, the employer closed down the business, but they still pay like 75% of wages to you, then you cannot claim for the benefits under the Social Security Office. Because to be entitled to that benefit, you must be not, you do not work, and you do not receive wages from the employer at all.
Right, and are there many maximum amounts that you can claim from the Social Security Fund, or you can claim for whatever at the amount that you contribute to the Social Security?
No, it's have like limited, and it's not that much, because it's like actually it's like 62% of the employees' wages. But when we talk about wages, it's not your actual wages. When we talk about like cap wages under the Social Security Office, we talk about like 15,000 baht. So it's not that much.
Okay, right. Okay, so we move to the next question from Chris Stratcher. So he's wondering that if an employee feels that they have been terminated the employment contract because they were not very good or effective enough in terms of working from home, but had no previous concern raised by the employer, can they claim unfair dismissal on that?
I would. It would, if you would like to claim for unfair dismissal, this will be, I mean, when the case has filed with the court, this will have to be proved on a case-by-case basis. And it would be by recommendation that you claim for that amount, because according to the law, the burden of proof will be shifted to the employer. There would be the party who need to prove that they has like necessary grounds to terminate the employee's employment, which normally quite difficult to prove so.
Okay, right. Thank you. So we move to the next question is from Kun Tanuchaporn, and she's wondering that if, let's say, if the employee does not give the consent when it comes to the salary reduction that the employer asks, and the employer decides to terminate the agreement at that time, would it consider as the unfair termination?
It could be, as I already mentioned, that this depends on the facts on a case-by-case basis. So they have a chance, they have an opportunity that this might be considered as unfair dismissal if they have like some facts. For example, as the case that I mentioned before, if the employers reduce the employee salary as the first step to try to terminate them and to make them entitled to less amount of severance pay, this might be one of the reasons that you include when you claim for unfair dismissal. So you have to collect all the evidence. I would say it's factual evidence. So this is not the legal matter, it's kind of factual matter.
Okay, right. And can you just contact to the Labor Department regarding to this matter?
No. For the damages for unfair dismissal, you cannot contact the labor officer. You have to bring the matter to the court only, because the labor authority, the labor officer, that's under the Labor Protection Act. But for this unfair termination is under another law, so you cannot just go to the labor officer.
Okay, right. So we have to go through, let's say, civil court, isn't it?
It's labor court.
It's
labor court. Yes.
Okay, so move to the next one. I apologize, I'm not sure how I pronounce your first name correctly, but I will say Jean François then. He's just wondering that in terms of we reached to the mutual agreement for the salary reduction. So how it will work with the benefit, let's say all of that allowance for the expat, like the house allowance, accommodation, phone or whatsoever in that case?
So it will apply the same concept. So it means that if you agree to reduce your wage, it does not mean that you agree that your welfare package will be reduced as well. If the employer would like to reduce your welfare package, they also need your express consent on that particular issue. So it means in the consent form, in what's whatever format that we have just discussed, it must specify both the reduction in wages and in welfare. If it specifies only wages, it will not include your welfare. But you should be careful because of like some welfare, they might link to salary or may link to wages, but you have to look into that on a case-by-case basis.
Okay, right. And for, I think probably last question of this session today will be from Kun Chonnasha. And she's wondering that if an employer asks an employee to take leave without pay, but the employee does not want to do it, and what can the employee do if he wants to keep working and get paid? Basically, like there's only one side, is not the consent from the employee at all to take the leave without pay.
Actually, for the leave without pay, it also needs the employee consent as well. So if the employee say they do not want to leave without pay, the employer will have no choice. They still need to pay the employees. Yes, and even they want to, they may order that, okay, the employee do not need to come to work. Even though despite that order, the employer is still entitled to full wages unless the employer and the employee negotiate and the employee agree to reduction in wages or to take leave without receiving any wages at all. So the employer cannot force the employee to take leave without pay.
Okay.
They may, however, because according to the law for the annual leave, according to the law, the employer may designate, like they may specify some days for the employees to take annual leave. This is possible and the law allows to do so. But you should check your employment contract or the work rules if they have like specified something different from the law or not.
Okay, right. What if vice versa? Let's switch the case. If let's say the company still run as normal, daily routine work, normal working hours, and the employee feeling like they don't want to go to the office because probably they're afraid to get the COVID-19 somewhere or whatsoever, can the employee say to the employer that I will take this maximum holiday that I have per year during this time, and we still got pay in the end of the day?
Yes, that is possible because the right to take annual holiday is the employee's entitlement under the law and also under their employment contract. So if they do not want to come to work, they can ask the employee to take all the annual leave that they have in order to be, not come to work at that time and still receive wages from the employer. But if they do not take any leave, they just like disappear, there will not be like no legal ground, and the employer can use this and apply the no work, no pay principle, and the employees will not get paid at all because they do not come to work for the employer.
Okay. Are there any further questions through the webinar? I think, okay, that's all for the Q&A session then. So I would like to take this opportunity to thank Kun Kwang, and thank you so much for generously sharing your time, especially it's a public holiday, and also sharing your knowledge and expertise with us. These are very useful information, and in the end of the day, it's good to know what is your fundamental rights before you're gonna reach to like negotiation time. So thank you, Kun Kwang, again, and I believe that the best way to do if we reach to this circumstance that you have to like discuss or have some matter or issue with your employer, compromising is the best way, isn't it, Kun Kwang? So like we don't have to like drag the issue way too much, and we both can like end in a good term.
Yes, and actually, from my experience, I think like many employers are trying to sustain this situation by complying with their rights and also the employees' rights under the law, and they might apply for certain things such as like Section 75 of the LPA, pay the employees like 75%, but they're trying to mitigate, any loss or any damage that the employee might be affected from such decisions, such as they pay like financial assistance, or they're trying to make like negotiation with like clear statement, clear decision, like how they would like to take forward this situation. Like if they would like to reduce the employee wages, for how long there should be this kind of thing. If you cannot find this from the employer, I think you may need to be like a bit more careful. And I think negotiation or just like talk with the HR or the employer about this situation might ease your concerns.
Yeah,
They might have some explanation, some steps.
I would
Yeah.
say. And maybe before we're gonna leave, just have some kind of few questions. Just only one question from you actually between us in the webinar. So, and also Facebook Live as well. We're wondering that are there any upcoming news about the reschedule of the Songkran's holiday? That is it going to be in this? Do you have you heard any news that it's going to be in this soon or?
Not yet. We're still waiting. Not any official from the government, not from the local authority. I think they might wait, and I think they are like estimating the situation because we have like long holiday in May, so probably they are like estimate the situation. Yeah, if it would be possible for another long holiday soon, or if we got like more infected cases after this long holiday, I think they're gonna be postponed for the Songkran festival.
So guys, meanwhile, just try to stay home, and if you have to go out, just don't forget to wear the face mask or like keep, you know, like social distancing, I would say. Just help each other, and we really hope that the situation and things gonna get back to normal in this soon. So thank you so much for Kun Chanakan again, Ka, for joining us. And for those who, let's say, probably join our webinar a bit later on and you want to re-watch it again, just make sure that you click like in our Facebook and Instagram through like BCCT Young Professionals. Just click like and we have more update news for you. And for those who are our BCCT member, we also have another channel for you guys, which is called the BCCT Coronavirus Hub. So you just enter to our website, just type www.bcct.British Chamber of Commerce, Thailand, and enter to our website. On the first page, you will see the blue letter right down as a BCCT Coronavirus Hub, and you just click that. And as a member, we provide you the free advice about different kind of issues. I would say we have banking, we have legal matter, we have the BOI, we have employment stuff, and all of the advisors are our honorable advisory from our board of director and also our member as well. So make sure you use the benefits of that. And yeah, so thank you so much everyone, and see you again until next time. Take care.
Thank you.
Bye.
Bye.